We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today we want to look at the rule of law. Uh, Second year, first year students who are doing constitutional law, this is one of the very important and first topic that you must appreciate when understanding it, because this paper is going to make you constitutional lawyers. You must appreciate the principle of rule of law. First thing is, what is the principle of rule of law? These are things we are going to discuss. What is the principle of rule of law? What does it mean? The definition. Then after it, we are going to look at how has rule of law been manifested, for example, in Uganda. What are some of the features, the elements of rule of law? Then from there, we shall also talk on the negative side. So any question you meet in the exam or any day that is talking about the rule of law, this is very important. Number one, discuss what it means, the meaning of rule of law. Also, give us the definition as per Professor Dicey, and then tell us the elements, how it has been manifested. Then after, you criticize the negative bit of rule of law, that how has, for example, the government of this country failed to observe the rule of law. That is the way you answer that question. But we want to thank you for watching Law School Made Easy at Law School Made Easy 256. We urge you to subscribe, to share, and like our videos. So let's go into rule of law. Rule of law, the way you hear the word rule of law, that there is some bit of governance, but that governance moves with the law. So in simple terms, you would say rule of law means that you are being led by the laws. There must be great respect of the laws while governing the people. So that is what we mean by rule of the law. Professor Emeritus Kanyeyamba, in his book, Constitutional History, the History of Uganda, he goes ahead and says that the funny thing about rule of law is that the people who are leading and the people who are led are all controlled or governed by the same laws. So that is the most important, that the people governing and the people being governed are all subjected to the same laws. So this is a serious ground for you to critique. If you see any event in this country where the leaders are excluding themselves from being governed by the law, then just to know there is a failure on observing the doctrines of rule of law. For example, just explaining this definition. For example, if someone, let's say minister, is arrested, and they say that this minister is mandated, yes, of course, you are mandated to get bail. But if they say that this minister is so special that we have arrested him and now we need him to be at his home, we are arresting him from his home, our laws have not provided for that. So that one is now a serious breach on the rule of law. You must be subjected to the right channels. So meaning that you, the people who are being led, and the people who are leading you should all observe those laws. That is the most important. Now, this principle was amplified or described more by Professor Dicey in the 80s. Now, Professor Dicey, for him, says that the rule of law, for it to exist, there must be three things. And he built this rule of law on three principles. Number one, the supremacy of the Constitution. Number two, equality. Number three is just government. Justice must prevail in whatever happens in the country. Let us go slowly. Professor Dicey's principles of rule of law, there are three elements. You cannot start with equality or just government, what we call justice. You cannot begin with equality. You begin by supremacy of the Constitution. So the foundation of rule of law is the Constitution, as per Professor Dicey, that it comes on top, supremacy of the Constitution, Article 2.2. That is why in our Constitution, the 1995, we have the whole Article 2.2 of the Constitution, which says that any law or any custom that is inconsistent with the provisions of this Constitution shall prevail, but that other law, to the extent of its inconsistent, shall be void. This one is trying to tell you that the Constitution is a grand norm. There is no, you cannot do anything that is not under the Constitution. Some people, let me tell you, if you go and read articles around 110 that talks about state of emergency and others, if you read Article 23, liberty, and then the exceptions to liberty, the president during COVID times, those maybe who are not lawyers, who do not know about the law, the president during COVID times subjected us to a lockdown. Now, people would say that is unlawful. He's violating the rule of law, but let me tell you, that one has been provided for in the Constitution. He was following his mandate in the Constitution. So, the Constitution is the supreme. We can do whatever we do, but anything that is encroaching on violating the Constitution, that one cannot be. And that means there is gross, there is a lot of infringement that is around the rule of law, that the people are not governed by the law for as long as you attack the Constitution. Let's take a case of Andrew Mwenda and another versus Attorney General. Now, in this case, the Mwendas were charged of seditious intention and seditious offense. Seditious intention was in the former Penal Code 120, Cap 120, Section 39(1)A, and seditious offense, Section 40(1)B. Now, this was encroaching on the peace of the president. You have talked about the president. But Justice Chikonyogo Kasule and others, in their judgment, they were clear. They said this was not clear on what amounted to breach of the president's peace, especially when people under the Constitution, Article 29, they have freedom of expression. They must say whatever they want, and therefore they declared Section 39(1)A and 41(B) of the Penal Code that have seditious offense and seditious intention and Constitution, that it was inconsistent with Article 29, with Article 43 and Article 44. So, what do we mean? That the Constitution is supreme. You cannot tamper with it. That is the first element and indicator of rule of law, as per Professor Dicey. Then, the second that he talked about is equality before the law. Is saying every man is equal before the law. You are equal before the law. No one should be segregated. That is when you know that in this country there is rule of law, because no one is being segregated. So, in our Constitution, we have a whole article that explains equality before the law. That is Article 21 of the Constitution, that clearly provides and says that no one should be discriminated on lines of political, social, economic, cultural aspects. And then in 21 clause 2, it says that no one should be segregated on lines of sex, color, age, and others. What do we mean here? That there should be equality before the law. No one is above the law. No one is greater than others. This is not Animal Farm, where you say in the book of Animal Farm that we are not equal. That some animals are equal than are more superior than others. That does not exist. There must be some bit of equality. And I want to urge everybody here to look at the case of Charles Dimanche versus Makerere University. That case of students, Advent students, who were contesting that they were being segregated because they were teaching on Saturday, yet for them they were Advents. So that case clearly shows that there should be equality before the law. So as you discuss the elements of rule of law as per Professor Dicey, I have said I want to echo this. Students tend to forget, and what comes in his head, equality, you begin with it. That would be wrong. We begin with the supremacy of the Constitution, and then we go to equality. And then finally, there should be justice. Justice might prevail. Professor Dicey is saying, just government, that a government that people respect is a strong government. Now, by the word strong government, it doesn't mean that it should be like myself, very strong, you go, you beat people. No. Strong government means that people are respecting you. Whatever you say, people follow. That is what we mean by strong government as per Professor Dicey. That to exhibit justice in the country, you must have a government which promotes justice, and the people follow it. And if you see in our Constitution, Article 28 clearly spells out fair hearing. There must be justice, speedy. That justice must be speedy. That if there is a case before the courts of law, they must work on it very fast. And that's when you know that there is rule of law. But having a case, somebody is being indicted, taken to police, is in custody, is remanded to Nizira for 10 years, waiting for a judgment, that one is clear and explains that there is no rule of law. So those are the founding elements that explain the rule of law. Now, in 1959, the International Coalition of Jurists sat and they expounded on these principles. Professor Dicey had given us three, that these are the elements. If you see that these things are not there in the country, know that there is no rule of law there. But they were now expounded, because if you look at the country, there are just three elements which Professor gave. Really, they may not cover the whole issue, but now they went ahead and divided one by one. And among the things they said that explains rule of law, presence of rule of law in the country, number one is the independence of the judiciary, as explained in Article 128. Now, the judiciary must be independent. That when you encroach, when you interfere in the works of the judiciary, then there shall be no independence. They even cite clear, number one, principles that, one of the principles, of course, they are all manifested in Article 128. We can also refer to the case of Massalu Musene versus Attorney General, but let us focus on these three. Number one, the tenure. That their tenure, they should have security on tenure. That a judge should not be working when he knows tomorrow is going to be sent away. You must give them that, the security of the tenure. There should be appointment. The appointment of the judges must be clear, and you know how judges are appointed in our country. The Service Commission recommends three names, and then the president affirms those names, appoints on those people who the Judicial Service Commission has recommended. So, and also the tenure, the security, that the judges must be free from all that. Now, when you promote that, literally, that means that there is rule of law, the independence of the judiciary. We go ahead now and break justice. The fair hearing in courts of law, that issues, cases before the judges must be heard on basis of fair hearings. Natural justice must prevail. If you don't have that, then that means you have violated the principles of rule of law. Then look at all the elements: the executive, the parliament, the judiciary, how they operate, and the people. Because remember, Article 1 of the Constitution, the power belongs to the people. Look at Article 59 that gives us the mandate to go and vote, that you must vote for your leaders. The moment you have a country where you cannot vote for your leaders, say after every 5 years, then there is gross infringement on the rule of law. But where all those articles and principles are promoted in the country, then there is rule of law. So you look at all those aspects of appointment. The IGG in 123, Article 223, and others. What are some of their mandates? Are they following the law? Because we are saying rule of law literally means that you are following the law. The people being led and the people who are leading, they are all led by the same laws, and you must uphold all those laws. Now, let us now cross, now that we know that we are looking at the negative sides of rule of law, that how do you know, for example, in a country like Uganda, that there has been disrespect, encroachment, infringement on the rule of law? For example, let's take the time when the Black Mamba sieged the court. The Black Mamba entered and sieged the court. That was violation of the rule of law. How do you go and you siege court? You switch off all the lights, electricity, and then you attack court. That was gross misconduct by the army, that for going and encroaching on the judiciary, because we are saying the judiciary should be independent. Let's get another simple example, and these things I'm saying, it is okay to write them in the exam. The other day when 2017, I think, when SFC attacked Parliament. Parliament is an independent body that is supposed to make laws. And for you to qualify to be in Parliament, you are either a minister or a member of Parliament elected by the people. But SFC attacked members of Parliament and beat them up. That is violation of rule of law. We have seen people in courts of law who are denied bail even after being in there, after, of course, 48 hours, and then I think Article 23(6) clearly spells who is supposed to get bail. 23(6). Now, after the prescribed time, we are seeing people not granted bail. That is all. You are encroaching on the rule of law. You are not following the law. The idea is that you're not following the law. So when discussing the negative side of rule of law, we expect to give us the events that are violating the law. What are the things which are done that are totally opposite from the law? But we shall expound more about these events when we do the video of separation of powers. Because remember, this country is built on 3 pillars. And those pillars are judiciary, legislature, and executive. So as we discuss the separation of powers in our next videos, you will be able to understand how to explain the negative and positive manifestation of rule of law. But for now, that is what you need to do when you are answering the question of rule of law. We have said in a nutshell that you give us a definition as per Professor Daisy, and then other definition from other scholars if they have defined it, and then you tell us how it has been manifested, how has the law been manifested, and then never fail to give us the negative, how the rule of law has been violated. We want to thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, and like our videos. Thank you.